Rahat Widsantiko. You can call me Tiko. My student number E1A or 25 and 100. Here I'd like to tell you about a case. The title is the Bribery Case in the Dismissal of the CPO export case that happened in 2021 to 2025. So let's check it out to the video. So let's jump to the background of the case. So this case involves Muhammad Arif Nuryanta. He was a former chief at South Jakarta District Court, and he is suspected accepting large bribes to influence the verdict in a corruption case that was involving the export of crude palm oil, or in Indonesia we call it here as minyak sawit mentah. The perpetrator's main motive was to obtain financial gain by manipulating the verdict in favor of the bribe giver. The bribes were given to manipulate the verdict in a major case, namely to ensure that three large companies that involved in the CPO export corruption case were acquitted, or in Dutch words we called it as ontslag van alle rechtsvervolging. This indicates a motive to obtain material gains from parties with an interest in the outcomes of the court's verdict. The bribes came from lawyers or legal representatives of the corporation itself who wanted a favorable verdict. So Muhammad Arif Nuryanta was involved in a conspiracy to achieve this result in exchange for money for himself. The amount of money allegedly received was enormous, amounting to tens of billion rupiah, which reinforced the suspicion that the main motive was to generate personal or group financial gain rather than receiving a small gift. During the trial, the prosecutor alleged that the money was given to influence the verdict. It is indicating that both the giver and the recipient of the bribe wanted a legal outcome that was designed to suit the interests of the bribe giver, thus confirming that there was an economic motive behind the verdict. Okay, let's move on to the chronology of the event. I will explain it in 5 points. This point is based on the year when it happened. So the first one is 2021 till 2022. A case of corruption involving CPO crude palm oil export policies occurred, involving large corporation, namely Wilmar Group, Musimas Group, and the Permata Hijau Group. Second is 2022, where the crucial case is happened. Bribes were given to the panel of the judges before and during the examination of the case at the Central Jakarta Corruption Court. The aim was for the judges to issue a dismissal, or in Netherlands word we call it as ontslag van alle rechtsvervolging. Next, to 2023 till 2024, the alleged bribery case began to be investigated by law enforcement officials through the stages of investigation, inquiry, and the naming of the suspects. Next, to the 2025, this case was heard at Jakarta Corruption Court, and at 3rd December of 2025, the 3 judges who examined the CPO corruption case were sentenced to 11 years in prison. Muhammad Arif Nuryanta was named a suspect around 12 or 14 April 2025. The hearing for the reading for the indictment and the prosecutor's charge was held on 20 August 2025. With charge of 15 years imprisonment, a fine of 500 million rupiah, and a compensation more than 15.7 billion rupiah. And on the 3rd of December 2025, Muhammad Arif Nuryanta was also sentenced to 12 years and 6 months imprisonment. Okay, so to make it easier to you to understand what I'm explaining, what I'm saying, so I already make a 5W plus 1H version of this case, so I will explain it to you in 5W plus 1H structure. First, who? Muhammad Arif Nuryanta. He is a former chief judge of the South Jakarta District Court. He is the bribery coordinator who distributed the bribes to the 3 judges who examined the case. Who are the three judges? First, Nuryanta, he is the presiding judge. He is the judge that also examined that case. And second, Agam Sharif Baharudin, he is the member of the judge. The third, Ali Muhtarom, he is associate judge. Those are the three judges that examined the CPO export corruption case. And beside that, we have also witnesses in this case. First, Wahyu Gunawan, he is a former junior court clerk, as well as the lawyers and the corporate parties also involved in this case as witnesses. Okay, the second structure is what? Criminal acts of bribery of judges and money laundering in the settlement of a case of corruption involving CPO exports. Muhammad Arif Nuryanta is not only charged with accepting bribes but also with concealing, storing, and transferring the proceeds of the crime. Third, why? It is to obtain material gain by influencing and manipulating the judge's decision. Where it happened? It happened in the South Jakarta District Court and Jakarta Corruption Court. How it can be happen? In the CPO corruption case, the defendant corporation had an interest in being acquitted, so to avoid the criminal charge and the obligation to pay trillions of rupiah in as a compensation, bribes were handed over through the intermediaries such as lawyers or parties with access to the judicial system. And there was an agreement between the judge to secure the verdict by influencing legal considerations to ensuring an acquittal. The money was handed over the stages in large amount, around tens of billions of rupiah, through other parties' account, cash transfer, and various concealment schemes. Once received, the money was disguised by being deposited in the name of other party, transferred to a different account, or made to appear as a legal transaction so that prosecutor could also charge the parties with money laundering. The acquittal was indeed handed down, with the judge stating that the acts were proven but concluding that they did not constitute a criminal offense. The money trail was uncovered through tracing the flow of funds, communication between parties, and statement from intermediary witnesses, leading to the judge being named as a suspect. So you must be wondering what are the laws that being violated in this case, what are the rules that being violated in this case. So I wanna tell you about what are the laws, what are the rules that being violated in this case. So the first one is law number 31 of 1999 in conjunction with law number 20 in 2001 concerning the eradication of corruption crimes. The second, Article 12, letter A and B of the anti-corruption law. The third, Article 6, paragraph 2 in conjunction with Article 18 of the corruption eradication law. Fourth, Article 55, paragraph 1 and the first number of the criminal code. The last one, law number 8 of 2010 concerning about money laundering. So after you know about what are the rules and the laws that being violated in this case, you must be wondering about what the prosecutors charge and what is the judge's decision about this case, about three judges and the ex-former chief of the Jakarta District Court. First one is about the prosecutor's charge. The public prosecutor demanded a prison in 15 years for Muhammad Arif Nuryanta and a fine of 500 million rupiah with subsidiary penalty of 6 months imprisonment, accompanied by a demand of a compensation. That is the prosecutor's charge for Muhammad Arif Nuryanta. And there is also the judge's decision for the three panel judges. The first one, Chuyamto, he was sentenced 11 years imprisonment and fine of 500 million rupiah or 6 months imprisonment as a subsidiary, as well as compensation of 9 billion 211 and 864,000 rupiah or 4 years imprisonment. And the second, there is Agam Sharif Baharudin. He was sentenced 11 years in prison and a fine of 500 million rupiah with a subsidiary 6 months imprisonment, as well as the compensation of 6 billion 403 million 780,000 rupiah with a subsidiary penalty for 4 years imprisonment. And the last one, the last judge who examined the CPO export corruption case is Ali Muhtarom. He was sentenced also 11 years imprisonment and fine of 500 million rupiah with a subsidiary penalty of 6 months also, as well as the compensation of 6 billion 403 million 680,000 rupiah with a subsidiary penalty of 4 years in prison. In every case, there must be an evidence or witnesses. So I will tell you about the evidence. I will tell you about the witnesses' testimony in this case. So the first witness is Wahyu Gunawan. He is a junior clerk who acted as an intermediary for the flow of the bribe money. He admitted to actively contacting other parties to handle the CPO case and stated that the first bribe given to Arif are amounted to 5 billion rupiah. The second witness is Emmanuel, or as known as Oki. He is the driver of Muhammad Arif Nuryanta. He stated that the initial communication regarding the case came from Wahyu Gunawan, not directly from Arif. Third, the examination of other witnesses. There are Marcela Santoso. He is a corporate lawyer from the corporation, and there is also Arianto Bakri. He is also a corporate counsel for the corporation also. And there is Muhammad Safei for Wilmar Group, also for the corporation, from the corporation. The investigators found records of requests for acquittal and documents related to the money transfer for the bribe money. So what is the fact about the fund flow in this case? So we have heard about the testimony from the witnesses. So those is their testimony, but we have to know the fact. What is the fact? So this is the fact. I will read it for you. The total amount of alleged bribes was around 6 billion rupiah. That was really big money. So approximately 22.5 billion rupiah was distributed to the three panel judges that mentioned it before. Muhammad Arif Nuryanta handed over approximately around 6.9 billion rupiah to investigator on 19 June 2025. The bribes were reportedly given in two stages. The first stage was approximately around 500,000 US dollar, and the second stage was approximately around 2 million US dollar. Arif's shares is said to have reached approximately around 12.4 billion rupiah in one version of the disclosure. The charge filed by the public prosecutor against Muhammad Arif Nuryanta was filed based on Law Number 31 of 1999 in conjunction with Law Number 20 of 2001 on eradication of corruption crimes, particularly Article 12, letters A and B, and the application of this provision is legally appropriate, as the defendant was a judge who accepted large bribes to influence a court decision. All essential elements of the offense, including the offender, the receipt of unlawful benefits and the intent to manipulate a judicial verdict were sufficiently proven. The use of Article 55, paragraph 1 on point 1 of the Criminal Code concerning participation is also justified, given that the crime was committed collectively with other judges and intermediaries. In addition, the application of Law Number 8 of 2010 on money laundering is relevant, as the bribery proceeds was concealed and transferred to disguise their illegal origin. Regarding sentencing, the 12.5-year imprisonment imposed on Muhammad Arif Nuryanta falls within statutory range of Article 12 of the Anti-Corruption Law. Although the sentence is legally valid, it may be considered moderate in the light of the large amount of bribes involved, the defendant's high judicial position, and the serious impact on public trust in the judiciary. Nevertheless, the verdict remains significant as it affirms that judges are also subject to criminal accountability and that corruption within the judiciary will be punished. So yeah, the case is closed and the story is done, but I want to tell you a moral of this case, that at the end of the day, integrity and honesty are fundamental values. When these principles compromise, authority loses its legitimacy and public trust is eroded. Therefore, upholding integrity is not only a moral duty but the foundation of justice and professionalism. So I think that's it from me. I am Pahati Disantiko. Peace out.